Okay.
I have a question. I have a question.
Yeah.
A friend of mine gave her 2 children. One, the son got a business. They bought a business for her.
Okay.
And the daughter she bought a house for her in California that she wanted. And they were supposedly saved a lot of money on taxes,
Okay.
on probate, because it was a very large estate.
Okay.
And she took care of it. She did the whole thing herself. She didn't use an attorney. And it was legal.
Gifting there's a lot of things to consider when you're doing gifting. Both, there's a gift tax that you need to consider. Everybody has a $13 per person exemption per year. So you can give out $13,000 to your daughter and her husband, your son and his wife, you and your spouse, and so you can really use that a lot. So we have a lot of people who do annual gifting programs. We also have people who choose to do larger gifts. They'll gift the house, like you said. Now that's obviously going to be over the gift tax exemption, so what happens? What happens is that you're required to file a gift tax return, which is a step that a lot of people miss, but you are required to file a gift tax return and show, I gifted $200,000, the exemption for the year was $26,000 for my spouse and I, so you have a gift of $74,000. Do you pay money on that gift at the time that you file? No. What it does, it goes against the amount that you can pass tax-free at the time of your death. So, and there's also lifetime gifting limits, so that if you go over $1 million, you're going to start paying the tax during your lifetime. So there's a lot of things to consider. Certain types of gifts and certain estate tax is going to come back into your estate depending on if you die within 3 years. It might come back in depending on the type of gift. But there is a lot of ability to save on some tax if you gift it away. But it's important that it has to be a completed gift, meaning you have to truly give it away. It has to be gone. You can't hold on to some sort of interest in it. So it really needs to be a true gift. You need to look at your estate tax and gift tax and what increments it has on that. But also on the flip side, you give away all of your assets and then you need care, and this is going to broach a whole other subject, is you're going to have medical assistance issues. What if I go in the nursing home and I can no longer pay for my care, but 2 years ago I bought my daughter a house? You're not going to qualify for medical assistance. So now your children are on the hook. Now you don't have anywhere to... So there's a lot of issues. Gifting can be a very effective tool and we do it frequently. But you need to be very careful when doing it.
529 funds considered giving it away totally?
They are, but you can gift, is it 5 years? 5 years at once. So you can gift 13,000 times 5 in 1 year to fund the 529 plan. But you can't then gift for the next 5 years. You've used it up for 5 years. And if you die within that 5-year period, then whatever year that will come back into your estate. So there is some ability with 529s to do a bigger lump sum on the front end of the 529 plan. But it is considered a gift. But then there's questions on, then this is, I haven't looked at this issue in a while. Medical assistance, the asset's still in your name. You're still the owner of that asset. So then there's questions about whether or not it has to be cashed out. And I haven't looked at that issue in a while because 529s, that wasn't really worked out the last time I looked at that. So 529s are a different sort of beast when it comes to that kind of stuff. So we've talked a lot about trusts. Those are the documents that you set up to actually hold title to your assets. So you're transferring the deed to your house into your trust. Your trust actually owns it, but you're, as a trustee, you still have complete control of it. You're transferring your accounts to your trust, your stocks and bonds. We do not transfer your tax-deferred accounts into your trust because that is a recognizable taxable event. We do not do that, so we keep those in your name. But trusts are nice. They do avoid that probate if you have everything properly titled. They also do have that continuity that probates don't have. Probate, you're going to have a lag. You're going to have 6 to 8 weeks before you have your personal representative appointed. That funeral bill sits there. That just kills people. Can't pay the funeral bill because I don't have assets I don't have access to the assets. It's just going to have to wait until you can get access to that account. Personal representative is not personally liable unless they sign that they are, which I don't advise people to sign that. They have no personal liability, so they just have to, sit tight on those bills. Trusts, we don't have that. We have automatic shift, and a lot of times we're seeing the shift happen even before death because they've kind of slowly been taking over more and more, depending on the circumstances. So there's a lot more continuity with trusts. You don't have probate, and there's also not that public portion to it. There's no requirement to serve the heirs. There's no requirement for publication. There's no requirement for the court to see any of it. Now, if you get into litigation, of course, it might become a different story, but it can help shelter some of that privacy that some people find very important.
I would bet everybody is wondering what approximately does it cost me to have all the government set up here.
Well, I can just speak for our firm. We do everything on an hourly basis, so we don't have any sort of flat fee because it really differs from person to person. Because when we're setting up a trust, some people may want more help funding, some people may have more questions, some people may have more opinions. But a trust, it can run anywhere from $1,250 to $4,000. And the reason we get higher, it's hard to really say what the hour bounds are. We're getting higher when we're dealing with like farm property, and we have to make sure that we have correct legal descriptions, or we're correcting and making sure that some of this title stuff is correct, or we're doing succession planning with businesses. That gets more expensive. So it's kind of hard to say, but it's pretty basic. You can do $1,500 to $2,500 and get a revocable trust. It's pretty basic revocable trust. We also always do powers of attorney and healthcare directors for people as well as parts of our plan, so that you have somebody named as your power of attorney and then someone to act on your behalf for the healthcare. We always do that as a package.
Now, we did all this summer, but will you review what a pour-over bill is?
Sure.
I know we haven't, but
Pour-over will is what goes with the trust. So we do a will when we do a revocable trust that says, I give anything in my estate to my trust. So that if there is an asset that gets missed, have that will to probate that transfers it to the trust. So basically the will pours over into the trust. That's why we call it pour over. Yeah. So it's kind of a safety net. So we hope not to ever use it, but we do every once in a while. Power of attorney is to deal with the financial items. If you don't have a trust and a trustee or an asset outside of the trust, power of attorney can deal with those assets for you. Again, it's a really powerful document because it's effective as soon as you sign it. If that person gets a hold of it, they can go to the bank and transfer your assets. Not legally. You have to do what's in your best interest, and there's gifting limits, but unfortunately it can be dangerous. But if you don't have it and you need it, then we have to go and ask for a court-appointed conservator to handle your assets for you, and then we have annual reporting requirements. So for the most part, for a power of attorney, for most people, is a good alternative. I tell people to put it where somebody can get at it, but don't necessarily distribute it right away if you don't need it. Yes, it does terminate on death. So I have a lot of people who continue to try to write checks to like the funeral home and whatnot with their power of attorney. And some of them, sometimes they'll get 1 or 2 checks through before the bank realizes that the person's deceased. And then they'll get cut off, and they'll have return check fees, and then people call in and upset with them. And it does end on death. So once that person passes away, you shouldn't be using that power of attorney anymore. It should either be a trustee or a personal representative. So I have the powers outlined there. Does anybody have any more?
so can you avoid some of that
Yeah, that's big. A lot of people do that. You can go to the funeral homes or some of the, they're licensed insurance agents who do them, prepaid burial accounts. I recommend that people do them all the time because then it's done, it's paid. You don't have to worry about who's going to pay it, how it's going to get paid. If you do PODs or transfers, then it's set up and it's paid ahead of time. The other thing is that's exempt for medical assistance purposes. So when I am talking with somebody who's going in the nursing home, they're looking at spending now to go on medical assistance, that's one of the first things that I advise people to go and prepay. Otherwise, either your children has to pay or you get the county burial, which they just reduced it, which makes no sense. But they just reduced the amount for the county burial. So prepaid, I'm a big fan of prepaid burials. It saves the family a lot of grief too when they don't have to make those decisions. They know the individual has already made those decisions. So.
What's generally the allowable limit now in Homestead County of social services?
For social services, as long as it's irrevocable and it's itemized, there's not a limit to it. So it's actually for burial funds. They don't have a limit. So you have to go to the nursing home. The insurance has to be written with a price list from one of the funeral homes. So, the casket, you have to show, the casket is $2,000, the burial plot is $500, the services are $2,000. You have to show every single item and include that list. So we have to submit that whole thing to social services when someone's applying for medical assistance.
And if there's more than what the funeral actually costs, then that extra is paid back
To the county. Yep. Yep. The county has to get anything over if you've been on medical assistance. Yes.
Can a person with a bank box designate a personal representative prior to their death so that that personal representative can access the contents of the box after that person's death?
My understanding is that the person has to be on there as an authorized signature person on the box already. Otherwise,
but if that happens, then you don't have this 6 or 8 week wait for a personal representative to be appointed before they can do something.
I don't know if I'm understanding quite what your question is. So if you have a bank box, a safe deposit box with someone named on it.
Right. Now, I don't know. I'm talking about Iowa.
Oh, okay.
It may be different in Minnesota.
Yeah. So that we're going to have a probate and a PR appointed to get access to any sort of bank accounts unless they're on there as a joint account owner. So you can get access to the safe deposit box if you have a joint account owner on there. But that would be...
So the designation of personal representative have an effect?
No, because nominating a person as your personal representative in your will gives them zero power until the court approves it.
Not in the will, on the bank box.
That's not going to meet the statutory requirements to name a personal representative. You have to have 2 witnesses and a notary. So it's not going to be considered appropriate, the right.
What if they're named on the deposit box but don't have a key?
Then they can have it drilled if you don't have a key. Yeah. Let me tell you what though. But I can tell you what though I've had happen in the past. So if you think that there is a will in a safe deposit box and you're not on the safe deposit box and you have the key, we can do an inventory search of that safe deposit box and the court knows what's in there and we can get the will in order to probate the will. If there is no key, the bank is not required to drill the box without a court order. So we have to get a court order to drill a safe deposit box. I've had it happen twice and found both boxes and
Best to have that name on the box as a joint signature. They have to have their signature on file.
So I tell people that if they're going to put important things in their safe deposit box, like their estate planning documents, they better have somebody else who can get into them and know where they are. It has caused so much hassle and so much grief, you can't get into the safe deposit box, I can tell you. The 2 times I've had to do it and get the court order, it's expensive, it's lengthy, it's not good. I don't know what else to say about it. So. Any more questions?
Now.
Okay.